Good afternoon, everyone, and thank you to Professor Antoine and the Faculty of Law for allowing me to be a part of this second symposium on race relations in Trinidad and Tobago. My name is Jason Nathu. I'm an attorney at law and a tutor at the Legal Aid Clinic of the Hewarding Law School. My presentation today will focus on the law, how it has evolved on the issue of race in the sphere of business and employment, and to perhaps later spark a conversation on whether the law, as it currently is, can be deemed to be sufficient and the possible way forward in developing the law in this area. When we talk about the legal position on any issue, it is always a good idea to talk about the supreme law of our country, the Constitution of the Republic of Trinidad and Tobago. Section 4 of our Constitution outlines the fundamental human rights and freedoms that are enshrined without discrimination by reason of race, origin, color, religion, or sex. Among these are paragraph B, the right of the individual to equality before the law and the protection of the law. And paragraph D, the right of the individual to equality of treatment from any public authority in the exercise of any functions. Now, this subsection speaks specifically to public authorities, and there have been several cases where persons employed or denied employment in the public service have been able to bring actions against the state for alleged discrimination, included on the basis of race. But until the Equal Opportunity Act came into being in the early 2000s, there was no specific legislative instrument other than the Constitution that dealt with the issue of discrimination on the issue of race. And of course, the Act brought relief not only for persons in the public service, but also for persons in the private sector. So while aggrieved persons may have had some form of redress to the High Court, where racially motivated disputes may have fallen under concepts such as wrongful termination, breach of contract, or maybe unjustified dismissal, the Equal Opportunity Act brought specific remedies for persons who have been discriminated against on the basis of race. Now, the Equal Opportunity Act deals with several things that impact on business and employment. Firstly, it applies to discrimination in relation to employment, education, the provision of goods and services, and the provision of accommodation if the discrimination is in ground of status, and that status includes race. The Act also deals with offensive behavior, which is reasonably likely in all the circumstances to offend, insult, humiliate, or intimidate another person or group of persons, is done because of the gender, race, ethnicity, origin, or religion of the person or group of persons in the group, or which is done with the intention of inciting gender, racial, or religious hatred. The Act created two separate institutions, the Equal Opportunity Commission and the Equal Opportunity Tribunal. So the Commission, the EOC, receives and investigates complaints from members of the public and, where possible, tries to conciliate such complaints. If a resolution cannot be reached, the matter may proceed to the tribunal, which is our discrimination court, where the matter is heard and determined by the chairman of the tribunal with the assistance of lay assessors. Both bodies have been operating for about 10 years. What that means, therefore, is that the tribunal is a relatively young court that is still developing its jurisprudence. Some features of the tribunal are that it is treated as a court with its own rules and own practice directions. The tribunal follows a similar process to civil high court actions. So documents are filed in a similar way. There are case management conferences at various stages. The chairman gives directions for witnesses to give evidence in chief through witness statements, and matters may proceed to full trial for determination. In this regard, therefore, the parties are usually represented by attorneys at law. The tribunal may award damages to compensate for the discrimination or offensive behavior, as well as costs. and decisions of the tribunal may be appealed to the Court of Appeal. It should be noted that the tribunal has awarded damages up to $242,000 on occasion to compensate the complainant for acts of discrimination in the course of their employment on the basis of race. The most recent award was that of Derek Salandi versus Petrotrin in 2017. The tribunal publishes all its judgments on its website at www.eott.org. So you can feel free to go online and read the judgments to see how the court came to its conclusion and how it formulated the award for damages. So of course, these are steps in the right direction from a legal point of view, but there are a few things that we have to consider. I've already noted that the tribunal is a young court and therefore the jurisprudence is still developing. While we have seen a number of cases that deal with discrimination in employment on the basis of status, that status being race, there is not yet any settled precedent on the other areas that concern business, namely the provision of goods and services or the provision of accommodation, and also judgments purely on the question of offensive behavior as it relates to race. Then, of course, there is the fact that litigation in any form or fashion is always expensive. The EOC phase may be more friendly to complainants, and the EOC fosters a more economic route of alternative dispute resolution by mandating a conciliation session to get the parties to sit together to try to find a resolution. But where the matters proceed to the tribunal stage, dollars and cents and the psychological cost of pursuing the action comes into play. And complainants of limited means may decide to discontinue or not pursue what may very well be a good claim unless they can access some form of subsidized or pro bono legal representation. And I should say as well that at present, the state's legal aid and advisory authority does not cover matters that are before the tribunal. In the employment context, where the alleged discriminators are corporate entities, they usually tend to have deeper pockets than the complainants. And as with any type of contentious court proceedings, there may not necessarily be a quick result if the matter proceeds to the tribunal. The parties would therefore have to commit to every stage of the court process. Evidence is another factor that requires serious consideration. And in the absence of clear documentation, the complainant will have to determine who could be potential supporting witnesses and whether they would want to give evidence on behalf of the complainant. Of course, someone should not bring an unsubstantiated or frivolous complaint, so this shows that there must be proper evidence before the courts. I want to turn quickly to some of the hot topics that may rear themselves in the workplace on the lines of race. There has always been a debate about hairstyles and what is considered to be professional. This comes up ever so often. I am not aware of any EOT judgments specifically on hairstyles, but we can well imagine that this is potentially an issue that may be brought before the tribunal. There was an example recently of audio recordings that surfaced that may fall in the category of offensive behavior. Again, this is yet to be tested before the EOT, but again, hateful or inciting words in a workplace environment may land persons in trouble. And then there is the vast wild, wild west of social media. Many companies are now putting policies into place, making employees accountable for what they post on social media, particularly if the comments may reflect negatively on the business. We have seen some development in the law of defamation in Trinidad and Tobago as it pertains to posts on Facebook and Twitter, but certainly this is an area that may also fall under the Equal Opportunity Act, and I'm sure that we will see cases of this nature over time. So before I end, I would like to throw out a couple of questions. I don't necessarily have the answers to these questions, but that's why symposiums like these are very invaluable. So I've seen calls from various sectors for more legislation. That begs the question as to whether the process created by the Equal Opportunity Act is sufficient to deal with race relations in the context of business and employment. We've already mentioned that there are several issues that are still untested, and therefore it may be too early to say definitively yes or no. But the bigger question is whether legislation alone can cure all of the issues as they relate to race relations in the workplace. There's always a philosophical question as to whether one can legislate moral or responsible behavior. How can we achieve a change in the mindset of John or Jane Public? Is it only through legislation? And what about the access to justice issue? Does more strengthened legislation automatically mean that all our problems are solved? As we consider these questions, I'd like to thank you for your attention, and I look forward to the continued discussion.